Okay. Ready, Rex? Yep. 1, 2, 3. Welcome back to the Washington State Bar Association regularly scheduled March meeting, which is proceeding as scheduled, though in a different venue and in a different format than originally conceived. I wanted to let people know about the situation here in Seattle at the State Bar. We are out of Rice Krispie treats downtown Seattle. But I did find this new addition, this Chex Mix that's stocked in the kitchen. It's pretty fantastic. No Rice Krispie treats there. All right, we're going right into our meeting. We're going to Legislative Committee matters.
Mountain Dew, sir.
Governor Clark, do you say something?
Yes. Okay. Mountain Dew. I mean, still there?
Yeah, the presidential stash of Mountain Dew is still remaining in the fridge. I give a lot of credit to Executive Director Nevitt's decision to shut down general public access to the WSBA, so people couldn't just wander in and loot our kitchen. But I did confirm it is still there. And now we'll move to Legislative Committee matters. Kyle, Governor Cicchetti, thank you.
There's a term for this, for the actors who request specific items in their dressing rooms.
The rider.
Rider.
Yeah, the rider. My rider is quite extensive.
I'm going to have to think of some writers for my administration. Thank you. Legislative Committee matters. We have two topics to discuss. First is the legislative session report, and then the second is recommendation regarding proposed policy, legislative activities of sections. And that is involving Governor Higginson, which is Governor Higginson back? Does not look like Governor Higginson.
Let's start with the legislative session report.
So this year was surprisingly less concerning, distressing than last year's for one major reason. You'll recall, we had the CRRLJ folks come and present on one piece of legislation that was a continuation of several years of work on the Model Act, and that did pass to the happiness of many of the representatives and senators who have supported that over the years. And I'll let our Outreach and Legislative Affairs Manager, Sanjay Walvakar, talk about that and other legislation of note. So with that, Sanjay, I'll hand it over to you.
Thanks, Kyle. Sanjay here. Can you hear me?
Yes.
Perfect. So as Kyle alluded to, we had a successful 60-day session in Olympia this year. I'll just expand a little bit on his comments and also expand a little bit on what you see in the report in your materials. And I believe that report made it into the late materials for this meeting. Two big highlights from the session. First, as Kyle mentioned, our bar request bill passed the legislature. This was Senate Bill 6037, brought forward by the Corporate Act Revision Committee, CRRLJ, of the Business Law section, and approved by the board in November. That bill, you may recall, makes some technical changes to RCW 23B and also adds a board gender diversity provision to the statute that applies to certain public companies in Washington. The second highlight of the session, which Kyle also alluded to, was that House Bill 1788, which would have repealed a majority of the State Bar Act, did not move forward this year. That was a bill that the board legislative committee was watching closely this session. So that's obviously some good news this year. We also had a number of sections involved in the legislative process this year. The family law and alternative dispute resolution sections provided some good input on House Bill 2806, which is a bill that would mandate mediation in certain family law cases involving children. That bill did not advance this session, but it's an issue that both sections are going to watch for next year. The Family Law section also provided input on the Uniform Guardianship Act trailer bill this year, testifying their concerns in the House and Senate. We also had the civil rights law section writing letters of support on several bills relating to a variety of issues, including vacating criminal records, private detention facilities, and open courts. We had the Uniform Commercial Code Committee of the Business Law section providing input to legislators and legislative staff on a wage lien bill that did not move forward this year, but is expected to resurface next session. The Administrative Law section had productive conversations with the Attorney General's office about policies surrounding Public Records Act required indexes. And I understand those conversations went well, and those conversations will continue in the interim. So overall, it was a good 2 months of participation by Wsba sections. The next legislative session is scheduled to begin on January 11th, 2021, and that'll mark the start of the new 2021-2022 biennium. Between now and January, we'll work with section executive committees to share information about the legislative process and to set up the best possible system for continuing our success and having a successful 2021 legislative session. So with that wrap up, I'm happy to answer any questions.
Sanjay, this is Alec.
Go ahead, Alec.
Yes.
Okay. So I'm just curious. I saw some activity about possibly a special session, but I think that was only to deal with coronavirus issues. But if a special session is called, what do you have to watch out for during that time? While it might be called for a certain item, can other things kind of come up since the legislature's back in session?
That's a really good question. So I imagine if they call a special session, it would be for the specific issue of dealing with the coronavirus. I don't have much on the agenda in the interim that would need to be addressed during the special session. But I think at this point, we're not certain that that would be called. But I'm happy to see if I can get more information about that and maybe provide a better answer.
Yeah, I think it would be a good idea to continue to monitor.
Sure.
Go ahead, Alec.
No, that was it. Thank you.
Okay. Any other questions for Sanjay? So I would comment that I think the result on 1788 had a lot to do with the WSBA's involvement and our continued attention and discussions that we were having with representatives and senators. And although there was a bit of a bump in the middle, for the most part, we heard that there was no appetite for moving that forward. It's my understanding, and you can correct me if I'm wrong, Sanjay, if it comes up next year, we don't have to worry about so much as a mere vote. It has to go through the entire process again. Is that correct?
That's right. It would be an entirely new bill number, and it would have to go through the legislative process starting from the beginning with the committee in the House of Origin.
And I expect that next year, as we have this year and last year, we'll continue to watch. And if it does come up, and it has come up in the past several years, we will be responsive to it.
That's right.
Any other questions for Sanjay about any of the legislative report? Okay, hearing none. Our second item, bullet point, is the proposed policy regarding legislative activity of sections. Governor Higginson has been very helpful in marshaling that and doing editing and revising to the policy. So I'll ask Governor Higginson to give her perspective and a status update.
Thank you. This is in your late materials at, let's see, late materials, and I don't think they're numbered, at least my pages aren't, but there's a memo to the Board of Governors, and then the attached 3-page proposed legislative policy for sections for everyone's consideration. But briefly, for background, we originally, our committee had been appointed by President Majumdar to consider a proposed bylaw change on sections in the legislative process. The committee had decided that no bylaw change was needed, as the bylaw was written generally enough that we could leave it as it was. But the consensus of the committee was that a policy should be developed to clarify how sections proceed with regard to developing legislation to be introduced and responding to requests for information for legislation, or taking a position on a bill and so forth. So the president directed that a policy be developed and considered eventually by the board, and this is the policy. It has gone through one discussion at our January meeting, where we had some discussion among the board, and then it was sent to the legislative committee to send out in turn to the section leaderships for their comments. There was initially no comment received. Then the legislative committee made a few changes, and that revised version was sent to the sections, and we did then get a comment. I believe it was from 3 sections: the administrative law section, the alternative dispute resolution section, and the legal assistance to military personnel section. And then the sections, WSBA sections team, which are not actually sections, but they're the staff of the WSBA who assist the sections, had some comments as well. The comments were considered at our last legislative committee meeting and approved. The draft that's in front of you then is a result of this work. What it's attempting to do, and it's similar to what you saw in the January meeting, but what we did was clarify a few things. For example, that we've called, instead of calling it the WSBA lobbyist, we're calling it the WSBA Legislative Affairs Manager. So because we have a paid lobbyist as well, and we wanted to be clear that we were talking about Sanjay's position, not our hired lobbyist. We also took out the reference to the JuCR analysis of the sections being conducted in conjunction with WSBA General Counsel, because there was some thought that the sections didn't necessarily need the assistance of General Counsel, and they would be able to request it if they wanted it. We broke this down a little bit further since the last version you saw, to provide that if, and this was in response to comment from one of the sections, if a section is taking no position on proposed or pending legislation but would like to work with the legislator or wishes to comment by providing background information, other assistance to the legislature, then that would not require a GR12 analysis. The section could simply provide technical drafting comments, typos, miscitations of RCWs, ambiguities, possible conflicts with other RCWs that are not a subject of that particular bill, suggested a mandatory language for clarification. They could simply keep our legislative affairs manager advised of and copied on the comments, but they weren't required to go through either the GR12 analysis or obtain approval of their comments. We also added that if a bill is being addressed by a section and they've gone through the GR12 analysis, they've gotten approval from the legislative affairs manager or the legislative committee to take whatever position they're taking and testifying as they're wishing, and then that bill is not addressed in that particular legislative session, but the same bill is carried forward to the next session, or the same bill is introduced in a subsequent session, the prior approval to the section for acting with regard to that bill is deemed to be carried forward for the subsequent handling of the very same bill without having to go through the whole approval process again. So if the bill is not identical, though, they do have to go through the approval process, the GR12 analysis, and so forth. So those are effectively the changes from the prior version. So what you have in front of you then is the result of attempting to address if a section wants to originate legislation, what to do if the section was taking a formal substantive policy position on a bill, either supporting or opposing, or if the section wants to make some technical corrections. So those are the three different areas we attempted to address, and happy to either to answer any questions you may have, or otherwise, I'm sure any of our committee members would be happy to talk with you as well.
Thank you. Thank you, Governor Higginson. Any questions for Governor Higginson? Okay. So I envision maybe one more meeting with the legislative committee, since we left it with some additional revisions that needed to be done, and it looks like those are done now. So we'll probably need to present it one more time to the legislative committee, and then we'll most likely have a recommendation to the board after that.
Kyle, if I may suggest, I actually thought this was on for action today. That's why we were working to get this in front of the committee. All the changes that were made based on the discussion we had at the last meeting. Now, granted, everyone hasn't reviewed this and formally said, everyone meaning the legislative committee, said, yes, it's fine. But I took the language that we had discussed and agreed upon at the meeting and just flopped it into this policy. So I would respectfully disagree and suggest that if the board wishes to act today, that they should be free to do so.
My only concern about that is that we don't necessarily have a proposal coming from the committee. I'd rather have a committee proposal recommendation and at least know whether people have differing opinions on that. And I would expect that we probably could fit this in on the April meeting, could we not, President Majumdar? So we would only be talking about a delay of 1 month.
All I can say then is I wish I would have known that, because I dropped other things to fix this up. And it appeared at the last legislative committee meeting that we were in agreement that this was then going to be submitted to the board as part of the late material. So I'm a little disappointed that apparently there was a miscommunication, but so be it.
That may be my fault, my misunderstanding, but I would feel more comfortable having one more meeting on it.
Are there any members of the public on the public line who would be interested in commenting on this matter? I'm saying that somewhat slowly and adding extra words to my sentence, just so people on the public line who might be interested in commenting could chirp up. Okay.
All right. With that, we'll conclude our presentation. And like I said, I anticipate we'll be voting on this at our next meeting.
Is that a motion?
Do I need a motion to add it to the calendar?
Just need a motion to do something with it.
Well,
The agenda, I think.
may I make a motion? I actually don't like to lock horns publicly with my esteemed colleague, but I would like to move that we adopt this policy. The committee was in agreement on the language as we discussed it, and all I did was flip it into the prior draft, and I believe that it was communicated to me that this was important to get going so that our sections would know what to do when it comes to preparing for the next legislative session. So I'm going to move that we adopt this policy as proposed.
May I comment?
Sure.
It's March 19th. We have time, plenty of time before the next legislative session. I'm troubled a little bit about utilizing our committee, but not actually having votes or a proposal. And so, with all due respect, I would like to go through that formality.
Well, if there's no second, then that answers the question. So
I seconded it.
move as they wish to move.
All right, I heard a second from Governor Swagel. Any more discussion on this matter? Governor Abel.
Thank you, Mr. President. So just briefly on this point, I'm not on the legislative committee. I was not involved in the process of drafting this, and I am sympathetic to Carla's point that we don't want to be a slave of process and trying to move things forward. That said, my inclination would be to try and have a vote by the legislative committee to get us a proposal that is ready for our review. As Governor Trustee pointed out, we have some time between now and the next legislative session. So that would be my instinct on this. The other piece that I am still thinking about and grappling about and may try and provide some feedback to the legislative committee is on the removal of the GR12 analysis being conducted in conjunction with the general counsel. My concern is that all too frequently there is no GR12 analysis conducted by sections, that sections don't seem to get over, don't seem to be able to pass. And that might be the right result, but I think it would be appropriate to have that in conjunction with council. Thank you, Mr. President.
Any other governors? All right, with that, I'll move on to a roll call vote. This is to approve the policy today. Governor Stevens.
No.
Governor Tollefson.
Excuse me, aye.
Governor Peterson.
Aye.
Governor Higginson.
Aye.
Governor Clark.
Aye.
Governor Schicchetti.
No.
Governor Swagel.
Aye.
Governor Grabicki.
No.
Governor Knight.
Aye.
Governor Angelville.
No.
Governor McBride. The Oracle of Olympia, Governor McBride.
There we go. Votes nay.
Abstain. Governor Abel.
I think he said nay.
Oh, it's a nay? Oh, okay. Nay, as in no. Governor Abel.
No.
Wait a minute. Look at that.
Hi.
6-6 votes. 6 yes, 6 no. The first time in the presidency. The one thing I hoped would never happen. Doesn't seem like you guys are, my observation is, with the discussion here at the table, there isn't a lot of necessary conflict over the substance, more over the procedure. And if the chair of the Legislative Review Committee thinks it's important for that process to happen, I will vote not to pass it at this time. The motion fails.
Thank you.
But I do promise it will be back on the next agenda, regardless of whatever the legislative community does or does not do with it. Next, we have proposed amendments to the Wsba bylaws. There's a second read on Article 3, judicial status. This was the domain of Governor Hunter and Chief McElroy's hard work. Governor Hunter is not here. We're looking at things on page 216 of the materials. This is on for second read. We previously heard this matter on January 2020 meeting. It is now on for action. Just to let the board know, I have submitted briefing materials to the court on this in anticipation of passage, but I told the court I would let them know if it didn't pass also. But I wanted to make sure they had the materials before our meeting with the court, which didn't end up happening. Chief McElroy, would you like to address any comments or if anyone has any questions for you? You want to give us a brief overview about what this is again to refresh everyone's memory?
Sure. This proposal is essentially, it's the second reading on a bylaw amendment that would change the requirements for judicial members who want to change to a different status after they've left judicial office. Makes it much easier for them to accomplish that. The second page of the memo describes exactly what the changes are. And this, as I understand it from Governor Hunter, has been a popular proposal with the judges.
That is my impression. Any questions or comments, Governor?
That's Dan Clark here.
Governor Clark.
Yeah, okay, it's awesome work. So okay, so I'll move with this.
Thank you. There's a motion by Governor Clark to approve this bylaw amendment.
I'll second that. This is Brian.
Governor Peterson has seconded that. Any more discussion on the matter?
Just quickly.
Governor Cicchetti?
We did mention this at the last Board of Judicial Administration meeting as one of the things that the Bar Association was working on, and it did garner some interest and encouragement, so I thought I would add that.
Any further comments or discussion? Nope. Okay, I'll start a roll call vote. Governor Stevens.
Aye.
Governor Tollefson.
Aye.
Governor Peterson.
Aye.
Governor Higginson.
Aye.
Governor Clark.
Aye.
Governor Cicchetti.
Aye.
Governor Swagel.
Aye.
Governor Grabicki.
Aye.
Governor Knight.
Aye.
Governor Angelville.
Aye.
Governor McBride.
Aye.
Governor Abel.
Aye.
I count 12 votes, a unanimous vote to pass an amendment to our bylaws and to send them to the Supreme Court. I have sent the briefing materials to the Supreme Court, and I will confirm with the Chief Justice this evening that the board has in fact passed them as I have in the form I've sent them to the Supreme Court in. So it is my anticipation that the Supreme Court will be considering these, assuming their en banc will be functioning virtually in about a week or two from now. Next, we move on to proposed comment to changes suggested to Criminal Rule 3.1, Criminal Rules of Courts of Limited Jurisdiction 3.1, and JuCR 9.2 regarding the death penalty. We have a presenter on this, the Council on Public Defense's Vice Chair, Travis Stearns, as well as the WSBA's Equity and Justice Manager, Dana Singleton. Mr. Stearns, I see you're present.
I am.
And Ms. Singleton, are you present?
This is Kevin. Diana's had to take another call, but Travis will be presenting.
Wonderful. Mr. Vice Chairman Stearns, thank you so much for joining us. Please tell us a little bit about this and what's happening and what you want done here.
Sure. So late last year, Justice Fairhurst introduced a number of rule changes that would eliminate the death penalty or any consideration to the death penalty from the court rules. The rules that we were at the council concerned with were the rules that would eliminate the standards from consideration, or that there would no longer be standards. And while we support generally the idea that if there is no death penalty, there is no need for standards, while that is technically true right now because of the unconstitutionality, it is not true from the legislature. The legislature heard considered the bill to eliminate it from the statutes. It made it through the Senate and made it up to the floor, but didn't result in a floor vote. And our position is that until that actually happens through the legislature, that the standards should stay in place. They take, as you know, an enormous amount of work to amend or to change, and until we actually don't have capital punishment in the state legislatively, the position of the council is that the standards should remain as they are.
And I forgot to mention for everyone following along, this is on page 223 of your materials, a memo to the Board of Governors from the Chair and Vice Chair of the Council on Public Defense, and their comment on that. And attached are proposed comments the council proposes to submit to the court. Does anyone have any questions for Vice Chairman Stern?
The one other thing that I just wanted to say is that it was passed without opposition in the council, as you know. None of the judges voted on it, but the council is fairly diverse. It includes public defenders, prosecutors, judges, and citizens. So,
wonderful. Questions or comments?
This is Alec.
Governor Stevens?
Yes. So, Mr. President, is it in order to move this? And then we can have the discussion around it, and I'd like to be first.
Yes, you are first, Governor Stevens.
Then I move to approve the proposal by the Council on Public Defense.
Okay, wonderful. Governor McBride, I saw you move your mouth, but I didn't hear anything. Did you say something?
Can I get a second from somebody?
Hi, this is Governor Tollefson. I second.
Governor Tollefson that seconded it.
So, Mr. President?
Yes, Governor Stevens.
Okay. I urge governors to pass this, especially until this is removed. The fact is, one of the biggest uneven parts about the application of the death penalty is its use and where it places people who have no money. Not only is there a issue regarding overrepresentation of people of color, but there is certainly an overrepresentation of people who are poor. And without these standards, until the death penalty is removed, and that's, of course, position taken by the Civil Rights Law Section and myself, these standards should remain in place for this is the population that is most susceptible to having the application of the death penalty happen.
Any other questions or comments?
Mr. President, may I ask a point of clarification?
Yes, Governor Higginson.
The motion, as is pending, would approve the Council on Public Defense's recommendation that the proposed amendments to the various court rules are rejected. In other words, that we leave those as are currently stated. I'm a little bit confused about
that is interesting.
Our vote.
Vice Chairman Stearns, is that accurate?
that's right. We're just asking that the standards, not the other rules. She proposed a slate of changes. The only ones that we're concerned with were the ones that would take away the standards, and we're just the comment is to leave them in effect until the legislature removes capital punishment from the books.
Okay, thank you. That's really helpful.
Any other questions, comments? Hearing none and a motion on the table, we will move to a roll call vote on death penalty. Okay. Governor Stevens.
Aye.
Governor Tollefson.
Aye.
Governor Peterson.
Aye.
Governor Higginson.
Aye.
Governor Clark.
Aye.
Governor Schicchetti.
Aye.
Governor Swagel.
Aye.
Governor Grabicki.
Aye.
Governor Knight. Governor Knight. Governor Angelo.
Aye.
Governor McBride.
Nay.
Governor Abel.
Aye.
10 votes in favor, 1 vote against, and 1 no vote. The motion passes. The Council on Public Defense will be authorized on behalf of the Wsba to submit this comment. Thank you so much, Vice Chairman Stearns, for your assistance and help and presence on this and advising the Washington State Bar Association.
All right. Thank you very much.
Bye. Thank you. Moving on, we have the Washington State Bar Foundation trustee appointments. We're going to be joined by President Christina Larry. Those materials are on page 225. And President Larry, are you with us? Governor McBride, do you have a hand up? Nope. Nope. Governor Cicchetti's just messing with the president. Okay. President Larry.
We're running a little bit ahead of schedule, so it's possible she's not on yet.
Who is the staff member that would interface with this group?